Hi, everybody. I'm John Feal, and we're going to watch a quick video, and then I'll come back and we'll do an intro, and we'll get this party started. Did you serve, work, or live at Camp Lejeune in North Carolina for at least 30 days between 1953 and 1987? You or your family may have been exposed to harmful toxins in the water. This exposure may have led to cancer, birth defects, other health issues, or in many cases, the death of a family member. While you've served your country, you and your family were being poisoned under the watchful eye of the United States government. Who knew that this water was contaminated? In August, President Biden signed the Sergeant Heath Robinson Honor Your PACT Act, which enables those affected by the toxic waters of Camp Lejeune to file a lawsuit against the federal government. My name is John Feal. I'm a 9/11 responder and advocate. I've made over 22 trips to Washington, D.C. with Jon Stewart to ensure that Congress did the right thing and passed this into law. If you think you've been exposed, please protect yourself and protect your family and make that call. Thank you. Thank you, everybody, for being here today. Thank you to every veteran who is watching this. Thank you for your service. And sometimes when we say thank you for your service, it sounds shallow. But we're here today to share information. And, people don't care how much you know until you show them how much you care. And that's why I chose to be here today with you all to work with the great people at Barasch McGarry and Grant Eisenhofer. And these two firms, they care. These men and women today are going to walk us through the process. If you were at Camp Lejeune from 1953 to 1987, not only for you who served there for over 30 days, but also your family. Also your family. Also, you might know somebody who passed away from one of the illnesses covered under this legislation. I'm here on Veterans Day as a veteran of the 101st Airborne and as a 9/11 responder, because this is important. We are talking about human life. We are talking about the well-being of you and your family who were lied to by the United States military. So we're going to get this party started. I want to introduce Beth Graham from Graham and Eisenhofer.
Thank you very much, John. And let me echo John's thanks to everybody who's watching, everybody who's in the military, and John especially, thank you. Thank you for being here today. As John said, I'm at a firm called Grant Eisenhofer. We are 65 attorneys in 5 offices. I've spent the better part of my 30-year career working on toxic exposure cases. I've represented a lot of folks, just like yourselves, in cases that have gone to trial that have involved terrible toxins that have caused awful diseases. I've tried cases involving these very same chemicals, these chemicals that are at issue, which include volatile organic compounds and benzene. On a personal level, I come from a family of first responders, which is how I met John and how I met Mike when they were representing my family in the tragic loss of my brother-in-law as a result of 9/11. My dad served in the military, so this is more than just a litigation to me. It's very personal. And as John said, the people that you see on the screen today, I'm working with them like Michael and Sarah and John because I believe in them and I believe in their ability to represent fairly the folks that are listening, all of our clients, and bring justice to you guys. So I want to talk a little bit about a lot of, I think, misconceptions that are out there about what the PACT Act does and what it doesn't do. Like John mentioned, there's a lot of information out there on the internet. I know my family, even I, have been getting inundated with Facebook ads, with letters, with things like that. And we thought it was really important to sit down with you all today and just do our best to explain the nuts and bolts of the act and what the process really entails for you to be able to protect your rights. So as John said, the Camp Lejeune Act is just that. It's a piece of legislation that was signed by President Biden in August of this year. And what it did was it allows individuals who are exposed to the toxins in and around Camp Lejeune in the coverage area, they call it, to participate in a lawsuit. Whereas before, the military, the United States government has a lot of defenses to claims. You cannot, as an individual, just bring a lawsuit against the government. There are doctrines that protect it. There's also statutes of limitation and statutes of repose, which are fancy legal words for meaning that even if you could bring a claim against somebody for something that happened in the past, that time is expired. So what the Act does is, for a period of only 2 years, 2 years from the date of signing, it allows people who are injured to bring a claim against the government for any of the injuries that they suffered. So August 10th, 2024 is the last possible day that somebody has to advance a claim. So what does that mean? First of all, I think a lot of people think that if they weren't stationed at Camp Lejeune, then they don't have a claim. That's not accurate. As you guys can see from the map that is up on the screen right now, the benefit coverage area, the area where we know that there were contaminants and where the government has said this is the area, encompasses more than just the military base. So for folks who are living within this radius, the presumption is that you drank the water or inhaled the toxins in some way, that you were exposed to the contaminants that were in the water. And if you became ill, you're entitled to bring a claim. Now, what does that mean in terms of what you have to do? So a claim under the Act is really a two-part process. Unlike the Victims' Compensation Fund, with which many of you are familiar, this is not a fund that is sitting there and has been established where if you file a claim, you will be awarded your fair compensation. What the Act contemplates is that you first have to file a claim in order to bring a lawsuit. So you file a claim with the Department of Navy. And then if the Department of Navy, their lawyers, who are called JAG lawyers, if those lawyers decide either not to respond to your claim within 6 months, or they reject your claim, or they make you a settlement offer that is unreasonable, you then would have to file a lawsuit. So it's really a two-step process. So anything that you're reading, or if any lawyer is telling you to sign up with them and you're going to be entitled to money automatically from this fund, that's inaccurate. What you have to do is file a claim, and you have to make sure that what you put down on your claim form at the outset is something that you can live with, because down the road, if your claim is rejected, whatever you filled out in the form, the administrative form submitting the claim, is what you're bound to. So what does that mean? If you say, I've got X, Y, and Z injuries right now, but your doctor has said that you think it's going to get worse, and you don't put that down on the claim, or you don't request enough in terms of compensation, your claim is rejected, you proceed to a lawsuit. Whatever you put down on that claim form, you're bound to, which is why it's really important to work with attorneys who understand not only the process, but the science, which you're going to hear a little bit about later, because the nature of your injury and the very basis of your claim can be pretty complicated. There are presumptive injuries and non-presumptive injuries, and Dr. McTire, who's on this call with us, is going to talk about it in much more depth than I'm qualified to do. But suffice to say that the claim isn't something that you should be doing on your own. You should be doing it in consultation with an attorney. So in this two-step process, we'll work with you to fill out the claim appropriately, whether it's for you, whether it's for a loved one, a family member. If the exposure was if you were 30 days within the area, and I'm saying 30 days, and I want you to pay attention to that. What's really important is that 30 days doesn't have to be consecutive. So you don't have to have spent an entire month on the base or in the area where there's coverage. If you were there for 1 week a month, you would be entitled, as long as in the aggregate you've got 30 days. So and the reason for that is it's pretty practical, right? If you're exposed to this toxin, it doesn't have to be 30 days cumulative for you to suffer an injury. You shouldn't have to have been exposed to any of the toxins that are in the waters. So if at any time between 1953 and 1987, you or loved ones were working at the base, stationed at the base, living near the camp, you are eligible to file a claim. And again, because this is going back for such a long time, it may be that certain of your family members have had diseases and you never connected those dots. So it's really important to ask questions, and you're going to hear a little bit about the diseases and the symptoms and such later. But if you think that you have a family member who is in the military and, for example, died of a cancer, now's the time to start asking questions. Now, the good news is at this point in time, because there are so many folks coming forward and filing these claims with the Department of Navy, at this point, we don't need to produce medical records or even proof of eligibility in terms of your personnel records. Right now, they've suspended that requirement. So we are working to gather individual records and the like. But at this point, the most important thing is to talk to us. Start to talk to your family members, figure out what's going on and whether or not you're eligible, because it's a very short window. 2 years goes by pretty quickly. It's already been a few months since the bill has been signed. So what we want to do is make sure that we are in the best position to not file claims for our clients just immediately, but to really analyze the injuries that are underlying the claims, and make sure that we're in the best position to get you the fairest compensation possible. So with that, I'm going to pass the microphone, so to speak, virtually over to Michael Barasch, my colleague and partner in this endeavor, with whom I'm sure many of you are familiar, to talk a little bit more about the process.
Thank you, Beth, and good afternoon, everybody, and happy Veterans Day to all of you who served. I assume that's everybody on this webinar. It is truly a privilege to be involved. I'm so thrilled to do this with Beth Graham and Grant Eisenhofer. I mean, you guys really do have the nationwide experience and reach. And, you know, we've been very involved with 9/11, obviously, since 9/11. Many of you know me and my partner, Sarah Director, who's also on the screen. Sarah, wave your hand, please. So we wanted to touch base with you. Sarah's going to talk in a few minutes about the intersection of 9/11 claims and possible Camp Lejeune claims, because there are landmines. And we'll be the first to say this. I mean, John mentioned it at the top of the show here. There's a lot that we still don't know. And those commercials that you see all the time on TV are, they're confusing. And the lawyers who profess to know everything, let me tell you something. Nobody knows everything yet, and that's really the truth. What we will do is tell you what we do know. I'd be remiss if I didn't mention on this day in particular that I am not just the managing attorney of Barasch McGarry, but more importantly, I am the son of Private First Class Marvin Barasch, who served proudly in World War II as a member of Patton's army in the 101st Division, walking across France. That was his proudest moment of his life, more so than my date of birth. But he was always raving about how those really were the greatest years of his life. What really got Sarah and I so interested in participating with Beth's firm were the parallels that we saw between 9/11 and when Congress and John John Stewart got this bill passed by Congress. Those of you who are my clients for 9/11 remember, and back in the day, Christine Todd Whitman of the EPA assured everybody in Lower Manhattan that the air was safe to breathe. Remember that? It wasn't. As the autopsy of our client James Zadroga proved, we were all exposed to ground glass. That's what they found in his lung tissue. Also, chromium, lead, benzene. These are all known carcinogens, many of them from concrete dust and jet fuel. Well, while none of the 9/11 clients we represent or the 9/11 community were drinking toxins in water like you were at Camp Lejeune, many of the same illnesses were caused by the same carcinogens. So similarly, well, first let me give Congress credit. While the EPA did mislead the entire 9/11 community about the quality of the air or the safety of the air, They did the right thing in 2010 when they passed the James Zedroga Health and Compensation Act. Here, it's a little late, but not too late for many, many people to get the justice to which they are entitled. Congress has done the right thing. We're hopeful that someday they will extend this 2-year deadline, but for right now, this is what we're dealing with. And Dr. McTire will talk to you about the illnesses that are presumed linked to the toxins at Camp Lejeune, and those that there's a good chance that they are linked, but there's no official presumption. So I do want to mention, those of you who are already 9/11 clients know that 68 cancers are presumed linked. There are far fewer cancers presumed linked, but there are other illnesses that are covered which are not covered by the Zedroga Compensation Act. I think it's important. There's one very big misrepresentation, and then I'm going to pass it along to you, Sarah. A lot of people believe that, oh, my husband died in 1989. It's too late to make a claim. No, it's not too late. That's the whole purpose of this legislation that was passed by Congress and signed by President Biden. You now have a window of opportunity to get not just justice, but to get financial security that could really make a difference in the lives of your loved ones. So please, even if you've lost your loved one, take advantage. And most importantly, I mean, we have about 150 people who signed up for today. Help us spread the word. You're going to get a recording, about a 30-minute recording that we're going to email you a link to that you can pass along to your friends, your colleagues, other family members. You're always free to reach out to us at militarytoxins.com. I mean, I think you heard it from Beth. I hope you hear it in my voice. You'll certainly hear it with John and Sarah. We take this personally, and we just want to make sure that you get the justice you're entitled to. So Sarah, would you tell us a little bit about the intersection of 9/11 claims and the Camp Lejeune litigation?
Yes, thanks, Michael. I just want to start by expressing my gratitude to all the veterans for their service. It really brings me great pride that I get to advocate for first responders and veterans on a daily basis. And I also come from a military family. My grandfather served in World War II, setting up evacuation hospitals in France and Germany. And my brother-in-law is currently in the Navy as an air traffic controller in Diego Garcia. So many of our viewers and clients, unfortunately, were exposed to both toxins at Ground Zero and at Camp Lejeune. So what are they supposed to do? So if you were exposed to both toxins and you're suffering from an illness that's not on the BCF list, which includes 68 cancers, then we urge you to get involved with the Camp Lejeune litigation. It does not jeopardize your victim compensation fund claim at all. For example, if you're suffering from Parkinson's disease, this has been presumed to be linked to the water at Camp Lejeune, but as of today, it's not linked to the 9/11 toxins. So that's one of the illnesses that is on one list, but not the other. If you've been diagnosed with a cancer that has been linked to both 9/11 and the water, what should you do? That becomes a little bit more difficult to answer, and I'm going to give you an example. If Bob made a claim to the Victim Compensation Fund for his bladder cancer and he received an award, and then he brought a lawsuit against the government for his Camp Lejeune bladder cancer. And then unfortunately, Bob died from his bladder cancer. His family would be barred from bringing a Victim Compensation Fund wrongful death claim because he was involved in the lawsuit. Also, if Bob received money from the government through Camp Lejeune, he would have an obligation to let the Victim Compensation Fund know this. And the Victim Compensation Fund may do nothing, or they could ask for money back. The most gray area we're facing is if Bob receives money through the claim process with Camp Lejeune. As Beth described, there is a 6-month waiting period. In essence, you have to file a claim form with JAG. That claim form technically is not a lawsuit. It's not litigation. It's what you need to do before litigation. So we're hoping JAG will settle a lot of these claims during the sub-6-month period. If that happens, we are hoping that the Victim Compensation Fund will use that as a set-off against any future amendments or a wrongful death claim. But in truth, like Michael said, we do not have all the answers, and we do not have this answer. Luckily, our firm does speak to the Victim Compensation Fund leadership on a weekly basis. So this issue has been brought up, and we will continue to push to get an answer to ensure all our clients, Camp Lejeune and 9/11 clients, are properly protected now and their families protected in the future. And I just want to highlight a couple differences between the Victim Compensation Fund and the Camp Lejeune litigation. One is a fund. It's not a lawsuit. You're not suing anybody. You're proving you were within the exposure zone during the exposure time, and you're certified with the 9/11 illness. We're certain that if we can do that, the Victim Compensation Fund will compensate you. However, they put a cap on the amount of money you can get for, say, a single cancer of $250,000. The Camp Lejeune litigation is a litigation. You're suing the government. It's a lawsuit. You have an adversary. There is no guarantees with the litigation. You could win, and even if you win, you might not win the amount of money you think you are actually entitled to. But with the litigation, there is no cap. There is no magic number, $250,000. That's all you can get, say, for your lung cancer. If you have lung cancer and you make the claim to the fund, the Victim Compensation Fund, they don't care if you have a family history. They don't care if you like smoking cigarettes. With the litigation, they certainly will care. They can look to your family history, and they can look to your history to try to devalue your claim. So there is more certainty with the fund and less certainty with litigation, but there is pros and cons to both. Another big distinction between the two is, like Michael talked about, a statute of limitations. The Victim Compensation Fund is open through 2090. So you can amend your claim. We hope you don't have to, but again and again, if you're certified with new illnesses, and your family can bring a wrongful death claim through 2090. August 10th, 2024 is the deadline for Camp Lejeune. Also, with Camp Lejeune, if you accept a settlement or the case goes to verdict, you are signing a release. You're waiving all your future rights. If you sign that release on a Monday and you're diagnosed with the new Camp Lejeune cancer on a Friday, you are barred from bringing that claim. Versus the Victim Compensation Fund, where you are able to amend and make additional claims and bring a wrongful death claim. There is a lot of distinction between the two, and we're happy to answer additional questions once we get some more guidance from the Victim Compensation Fund, but there's definitely pros to both programs. And I just want to thank everybody for giving us the opportunity to educate you and to learn from you as well today.
Thank you, Sarah. I hope everyone found that helpful. And by the way, we've already received a lot of questions. If you have questions, please submit it. If we don't get to all your questions at the end of this, we will get back to you personally and make sure that all your questions get answered, even if we don't have a concrete answer at this point. I'd like now to introduce Dr. Roseanne McTire. Roseanne is an epidemiologist. And doctor, what is an epidemiologist?
Thank you so much, Mike. I'm honored to be in this panel, and thank you all for your service. I am a card-carrying epidemiologist. If you don't know what that means, it's distinguished from a doctor, a medical doctor, in that we study diseases in people to understand the causes of those diseases and exposures, such as toxic exposures, and their effect on causing harm. And so I'm here to tell you that there's a lot of confusion out there in terms of the injuries that have been presented as possibilities in this situation with Camp Lejeune. And I want to talk about, I've categorized them in a way that hopefully will make sense and will be simple to understand. First, I'd like to talk about the 8 presumptive diseases. And presumptive means they're assumed to be true. And they're assumed to be true in terms of risk established by science and medicine by the government. These diseases, if you look down the list, they're mostly cancers, and that makes sense from the standpoint of the exposure to contaminated water. If you look at the literature, you'll find most of these diseases are well documented. They include adult leukemia, plastic anemia, and other diseases of the blood, a complicated word, but you don't need to pay attention to that. Bladder cancer, kidney cancer, liver cancer, multiple myeloma, and non-Hodgkin's lymphoma. These are all diseases that are diagnosed by doctors and that have a series of different symptoms, which we can talk about at a later date. I want to focus on Parkinson's because Parkinson's is different, as you know or may not know. It's pretty common. And the distinguishing signs and symptoms of Parkinson's are something that you may be able to think about to see if anybody you know, family members or friends of people who have been exposed in Camp Lejeune would have these. For example, shaking is a real big symptom in Parkinson's, not in everybody, but that would indicate the disease. Problems with balance, shifting, difficulty picking up things like that are things that one can look towards when you start thinking about claims that may be brought. Can you give me the next slide, please? Now, we go to non-presumptive injuries. I want to emphasize that the next category, which is the kinds of injuries or diseases that can result from exposure to this contaminated water and can be used to claim for health benefits with the VA, include the 8 presumptive plus these other 7. Breast cancer, cancer of the esophagus, infertility in women, fatty liver, lung cancer, miscarriage, effects of the behavioral effects, renal toxicity, and a skin disease that's called scleroderma. So we have 15 that can be claimed aside from the 8 that I just mentioned for disability claims. These can go into a claim for reimbursement of healthcare benefits. And then we have the last slide, which is other injuries. These injuries are not yet so well documented as the presumptive or perhaps the non-presumptive that I just described, but are injuries that are very possible based on science. And they include birth defects. And I want as an aside, because this hasn't been mentioned, in terms of people who are affected, if you have a baby who has a birth defect, for example, and was affected, was obviously the problem was in utero. If you were pregnant at Camp Lejeune and have a baby with a disability or a birth defect, that qualifies, as well as that baby later on, if that person would have a child with a disability. So the point here is that the risk continues and transfers over time. And that would have to be vetted out by the attorneys. And give you advice, but don't forget that, because that may include people you may not have thought about. So these are other diseases here that we can consider. The male infertility is important. Prostate cancer is often thought to be documented to these exposures, so that would go in here. And one that I think is important is diseases of the kidney, whether it's cancer or function kidney function, end-stage renal disease, kidney toxicity, anything that has to do with bladder and the kidney are important to consider. And that's it for me. I'm happy to answer questions.
Beth, I'm sure we're going to get to a lot of questions for Dr. McTire in a couple of minutes, but I think we should make sure that we cover everything. And why don't you introduce Sam?
Thank you, Michael. So one of the things that's come up in talking to the clients that we already have quite a bit is what about my disability benefits or my other veteran benefits that I'm already getting? What is the interplay there? We've talked a little bit about, other avenues of recovery through the VCF, but we've brought on Sam Dolce-Powers, with whom my firm works quite a bit. And he can talk to you a little bit about what the interplay with benefits is and how to protect any kind of compensation and benefits and entitlements that you're already receiving. So Sam, why don't you just give a little bit about your background and talk about how we save these people some trauma later down the road in dealing with benefits.
Great. Thank you everybody for having me here today. My name is Sam Dolce, and again, I'm with Milestone, as Beth said. We're a veteran founded and led organization. So our founder served 11 years, left as captain, flew choppers. We oversee payments of billions of dollars to thousands of claimants every year. So this is what we do. And we work with firms like Grant Eisenhofer and many other great firms across the country, providing this kind of guidance. We have plenty of attorneys on staff that deal with these types of issues. And basically, our role in all this is to ensure that you're able to make really good decisions. So we're not here to make those decisions for you, but more so to give you that information. And that's why we like to partner with firms like those you see before you today, because they're the ones that seemingly gain the information and then pass it along in an informative way, instead of trying to misguide people in order to making decisions that best serve that firm. Now, we're going to have to define two terms today, and they're terms and words that get thrown around a lot. And so I'm sorry to have to do this, but I think it's really important to understand two distinct concepts. That's need-based benefits versus entitlements. So need-based benefits are things that you receive because you're demonstrating a financial need. You don't have a certain amount of money in your bank account, you don't get enough money every month, and therefore you're going to be provided certain things from the government. That would be like Medicaid or food stamps, maybe a Section 8 housing voucher. Other things are entitlements. These are things that you get based upon a certain status or based upon a certain amount of time served, right? So it's things like Medicare based upon age, or your VA disability benefits, right? Based upon time served and status. There's also things like VA healthcare benefits. So most VA benefits are entitlements. Some are need-based, but most are entitlements. Now, if you file a claim or lawsuit, that will not negatively impact your entitlements, and it should not negatively impact your benefits. Just by filing of the claim, it doesn't mean that you're going to have a negative impact. I think that's really important, because once you file the claim, then you're working alongside a law firm to provide you guidance as you move forward. Now, winning a claim or lawsuit should not impact your entitlements. However, it could impact your benefits. And that's why companies like ours exist. So we're here to equip you with tools so that when you do receive your settlement, you're able to keep your benefits. And those tools are varied, right? There's different types of trusts. You can structure your payments so that you don't ever get more than a certain amount per month. You can do a spend down, so you can get a large lump sum, spend it on qualified expenditures. We can record that in a certain way and report it, meaning that you can get a lump sum and keep your benefits. However, these are tools that we would address later down the road once that claim or lawsuit is won. And so really what I'm here today to do is to just share this information with you, as well as answer any questions you might have related to benefits. Some of those are individual, right? And they're as specific as they can be. Our company's here in support.
Thank you, Sam. This is a team assembled for you. These people care. And while they're lawyers and doctors and You know, we can make fun of lawyers and doctors because I do that for a daily basis for a living. These people are good people, and I only surround myself with good people. And I believe you're getting the best information, and you're going to get the best care, and you're going to get the best help from this group and these individuals. But I implore you to share this with others, and I implore you to go to www.militarytoxins.com. If you have any questions, they'll answer them for you. And please, again, thank you for your service. Enjoy the rest of your Veterans Day. Be proud that you're 3% of this country that served, and hold your head up high and your chest out. And God bless you all. Thank
And
you.
happy birthday, John.
And happy birthday to John.
Goodbye, everybody.
Bye-bye.
Bye-bye.